let's see at what point in time does paragraph 15 operate? On the date when he files this application. It is 19th of July. Correct, Mullah? Can't be before that. Even if the Election Commission were to decide, it could only decide on 19th of July when he moves the Election Commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority. Then how does he move the Election Commission? And the Election Commission has no jurisdiction to decide whether he is a member or not. Paragraph 15 will operate when both sides agree that they are members of the party. Has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Bharat, of paragraph 15 operating at all in this case? Therefore, Bharat, to say that paragraph 15 is operative and is independent of all this, with the greatest respect, Bharat, is contrary to very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The Election Commission of India will decide much later. The question is,
Mr. Zippal, what's the next point now? We've got this part, this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there is a prima facie case. Slowly, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it would not be sitting here. 2, what's the balance of convenience today? That so far the Election Commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court of State.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all. There is no stay of BMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they said.
When they produce the order, there is no stay.
The best of knowledge. Hold on. Now, there is no stay today. The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court?
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP?
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Bagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with it. My learned friends are thoroughly different.
It's totally wrong. The last PMC election, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so he doesn't know.
No. I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, my lord. That order we have placed, my lord, in our written submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Jetlani. We'll hear you. Let's follow some. Yes. All right.
lot of enthusiasm moreover. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordship's Bharat, and it will determine, all the issues will be determined.
All right. So, prima facie case and balance of convenience.
And then, the irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What happened? It's irreparable injury. Was to be without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that. Anything else, Mr. Sibal?
Don't take time without repetition. Very
Who
clear.
are you appearing for, Dr. Singhvi?
Because there are 8 petitions I am appearing for the
All right.
eminent
Yes.
parties, because we are on this side versus that side.
And you will be characteristically brief, Mr. Dr.
I am
Singhvi.
grateful because we were characteristic.
Correct.
Your Lordship has always rendered me speechless before I started. May I be very pointed. Your Lordship has 4 points in the 10th schedule. The issue is narrow. Whether your Lordship's on a
Can you just formulate the 4
Yes.
points?
Before that, let me do that. Today, your Lordship is not hearing the matter.
Right.
Today, your Lordship is deciding the correct balance of convenience to endure till such time after Diwali, your Lordship hears the matter and renders judgment. That's the only issue today. Now, for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I will demonstrate that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Dr.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your Lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the Election Commission and the matter will not go on. There have been 3 dates in between, from then to now, including one coming up later this week or next week. So it has been adjourned. That was the Lordship understanding. Of course, subject to Lordship adjudication today, no doubt.
Till the application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements in the 10th schedule, which Mr. Sibal has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving Lordship original political party, and sometimes they say political party in the same context. If your Lordship sees 1C without reading it, it's been read to your Lordship, but just keep it open with us. Then 21A, and these are hard, these are the operative provisions. An explanation. So 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You should look at the subclauses. Then 2 bracket 2, and 4 bracket I, and many times in clause 4. Now let's.
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
Yes, yes.
Just as a matter of curiosity, I mean,
Yes.
nothing really would turn on this.
Let's, when they say
It's in 4. It's in 4. 4. 4.
4 in the merger,
Where is original political party merges with another?
the political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea in a minute I'll come back. It's the same concept. Now let's. This is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yeah, I'm
brief the
sorry.
argument?
Yes. So
Because
the
this
first
help
is-
us in.
Yes. Number 2, of the 4 elements, the first is political party. The second, split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big Bharat's pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet read, Your Lordship, not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3,
Directly?
that is exactly what the election commission is asked to do, the symbols order. I'm just saying, Wallace, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November, let the election commission go on. Because how unreal would that be? Kindly consider. How duplicated, how irreversible. Number 3, and the statement of objects is when we come to the final hearing, will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, common I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for us? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go, that means it's a new group. That group by itself makes no difference to the pension. Suppose, let me give an explanation. Out of 100, 90 go, or 75 go. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. Only merger is the sole defense. Bear with me on clause 4 for a minute. This needs to be read. Clause 4. That was the whole idea of substituting was merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. A member of a house shall not be disqualified under 2(1), where his original political party, the question Justice Chandra should ask, merges with another political party, and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you bought 75 are gone, 10 are left, 25 are left. And
So the people who remain after a merger,
Yes, sir.
their entitlement to be legislators is not taken away.
because
You are entitled to say, I don't form a part of the merger, I stay back and I continue with my own.
I'm very grateful, Manas. I'm very grateful. Because, Manas, and quite rightly, it is not their fault. The remaining 10 can't be disqualified because 75 have gone. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to Raj.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide authority by persons who, if they proceed, you will disqualify tomorrow. Because can your lordship form any part of a majority if somebody is disqualified? But deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Because it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Mr.
Now,
Kapil, you go to the next point.
You just note for something. Well, if you are, what happens is there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. And you merge and knock at the doors, you will be a new political party, subject to numbers. You want the best of both the worlds. You are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving a coach and forth through this. And the fifth point is, this thing was enacted, 15 years, 20 years after, on the Ayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the who is the real party? Party A, they are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only difference is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
One answer is that assuming it is so, I'm not conceding that, I'm just answering my lot of two alternative points. That has to logically follow, not precede. It's a
See, let me tell you, what is really troubling is this. The whole concept of disqualification is in relation to the House. All right? The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election. Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by our lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under an impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of.
I were okay to appear in the Election Commission in symbol order cases. What the issue?
Written in our compiling.
give your
I'll just give one.
There are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages there are.
Old one.
Old one.
Double one.
Common convenience volume. Old one.
क्या मेन पेपर बुक में है सर? हाँ.
Two or 3 things here.
What are you showing, Dr. Singh?
First,
So we don't get. I think what exactly are you showing? I can.
I am showing bullets in that volume, common compilation volume, the Election Commission notice at 698, page number.
One.
Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July 2022.
1853.
22nd.
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I tried to take a technical objection, but still that. Our training is still incomplete. That 22nd July. Now, will it?
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
that'll be very
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents
So,
after.
Bharat, that will be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. Bharat, I'm sorry, I'm not able to assist. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the 2 rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That page I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be was about 10 pages out here. PDF page, no PDF. My learned opponents, well, as filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen
I
here.
have said anything very seriously wrong, but this is very interesting what they have said. And this is 684.
684.
Yes. It's para 23, small Roman 23. Right? It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. They directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader is annexed. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so,
that petition can't be filed. So there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Because the filer, the approacher is Mr. Shinde. He's not a member of the Legislative Assembly. Is he not claiming on the basis of the legislative assembly status?
Right. Page 687.
Number 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislative wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC, 1972, volume 4 SCC, 664.
Now I think that is the
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only
Right.
status is that of a supposed MLA of the Shiv Sena, is what I will say. Now,
you are now reading Sadiq Ali.
Sadiq Ali, para
I think Sadiq Ali is part of the convenience
yes,
compilation.
page 14 of their convenience compilation, the other side, but your lordship can get it in so many forms.
Just give us a moment of
Para 26 there is. As your lordship knows, this judgment has stood the test of
Election
time,
Commission.
even though it is communicating on us.
Election Commission. Case 3.
yeah, I just saw it.
I'm great. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship is decided.
Yes, Dr. We've
That's why
got
I'm
it.
not concerned about the final merits.
Very
The lordship is told that it's two or north pole, south pole apart. It's two unrelated issues. That's what I'm objecting to. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says this is the organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. In view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the Election Commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength in our opinion is very valuable and relevant test. Then they go on. This is, of course, 68 is 15 years prior or 20 years prior to the schedule. Judgment is prior, but I am at the moment on the judgment's own terms. Can you separate? Can you, you are told that this is an unrelated issue. Then, Also note para 29, the last 4 lines. Majority of houses of parliament and sum total of members of state legislature. Last 2 lines of para 29 to save time. Last 2 lines of para 29.
In any case.
Last 2 lines of 29.
In any case.
3 lines.
Bilkul.
Now this third aspect, symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we are five. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Minister, your Lordship uses this phrase, it has become a commonplace. But it is a lot of weight. Not when the Supreme Court leaves it over, even lower courts. What is the meaning of this subject to outcome? We just say it like that. Your Lordship must find the iron guess. Your Lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singhvi, thanks. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your Lordship will